Those are votes that we have asked the court to review and make a judicial judgment on as to whether, under the law of Florida, the intent of the voter can be discerned from those ballots. And one of the issues that the court has been presented with is whether or not this court has to apply an abuse of discretion standard or whether it looks at that question de novo. And the court is aware that we believe that that is clearly, under Florida law, a judicial question to be decided de novo. And you have both the statute and case authority both going in the same direction. As the court knows, we rely on a long string of Florida Supreme Court decisions, not necessarily beginning with State against Williams in 1929, but certainly including cases at least back to 1929. We've also relied on State against Smith in 1932. And in that case, the Florida Supreme Court expressly stated that the ballots were the best evidence of how the contest should be resolved, and they were to be looked at as original evidence by the court. That's at 144 Southern at 336. That's State against Smith. The site is 144 Southern 333, and then the particular portion that I'm referring to is on page 336. In 1936, the Supreme Court decided Peacock against Latham. And again, the Supreme Court held that, indeed, it and the Circuit Court had jurisdiction to do an original count of the ballots themselves. Jumping to Beckstrom 2 years ago, in that case, the Supreme Court approved what the Circuit Court had done. And in that case, as this court knows, the Circuit Court had delegated to the clerk of the court the process of counting the ballots. And I want to take a detour for just a moment on Beckstrom, because the court has heard a lot about voter error. And there's been a suggestion here that in contest actions, if the court finds voter error, but nevertheless can discern the voter's intent, the court should disregard that voter intent. Now, there's never been a case that says that in Florida. There's nothing in the statute that says that. But defendants' counsel continue to argue that voter error somehow is an important concept to this litigation. We believe that Beckstrom should have put that to rest once and for all. Because in Beckstrom, the ballots that were at issue, the ballots that the Supreme Court ordered to be counted, were ballots in which there was unquestionably voter error. Just as the voters of the punch card counties have been told, punch all the way through, dislodge the Chad, get rid of it entirely, the voters in Volusia County, involved in the Beckstrom case, were told, fill in the bubble, fill in the circle with a number 2 pencil. But they didn't do that. Voter error. A voter error that made their ballots unreadable by a machine. But the Supreme Court didn't say, well, we throw those out. They didn't even say, we've got to look at all the ballots in the county. What the Supreme Court said is you look at these particular ballots that are the subject of the contest, and you determine, regardless of voter error, whether or not you can discern the intent of the voter. And the Supreme Court found that the Circuit Court was right, and that the Circuit Court could discern the intent of the voter, and so those ballots had to be counted. Now, in addition to this unbroken line of Florida precedent, you have the language of Section 168 itself, which casts a protest action and a contest action not in terms of an abuse of discretion standard for the contest action, but in terms of an original action before the circuit court. And it says the circuit court has to make the judgment. In the protest procedure under 166, discretion is given to the canvassing board. But in the contest section, 168, which of course is the section that is applicable to this proceeding, there is no provision for discretion in the canvassing board. There is no concept of abuse of discretion. There is no threshold requirement. So that section 168 is consistent with State against Williams, State against Smith, Peacock against Latham, the Beckstrom case, and all the other cases that we've cited to the court, in providing that this is a question for judicial determination. Now, it might be possible for the court to put that question off because the court is going to have to look at the ballots, whether it is an abuse of discretion standard or whether it is a original judicial decision. The court is also going to have to look at the Miami-Dade ballots, the 9,000, because there's been no discretion exercised. No one's even looked at those even once. But we would urge the court to directly deal with the issue at the earliest possible stage as to the appropriate standard to be applied, whether it is abuse of discretion or whether it is this is a original judicial determination that this court in the first instance has to make. And we do that because we think the law is clear and because we think that that will simplify the issues in terms of the ballot review and the ballot count. So with respect first to the 3,300 ballots in Palm Beach, which are the first group of ballots that we've presented to the court for contest and for counting, we think that that review ought to proceed as expeditiously as possible. Now, part of what the court will want to take into account, perhaps, is some of the evidence that the court has heard. The court has heard witnesses not called entirely by the plaintiffs, but witnesses called from the defendants as well, who have told the court that in a close election, a manual recount is the only way to be sure of how certain contested ballots should be counted. You've heard testimony from Judge Burton of the many kinds of ways that the Palm Beach Board found that people had not exactly followed instructions, about how sometimes they put it on top of the throat instead of in the throat, about how sometimes they don't punch it all the way through, about ballots that for whatever reason were dimpled in every race or dimpled in several races. So there was unquestionably a lot of ballots from which voter intent could be discerned, but the machine could not read them, just like in Beckstrom. Was it because of voter error? Was it because of inadequate instruction? Was it because of inadequate time? Was it because of a buildup in the Chad? And the court will remember that box almost chock full of Chad. And remember, that wasn't a box we selected. That was a box that was set up by the canvassing board. The court will remember the stipulation in which Miami-Dade agreed that it had not cleaned out the Chad in those machines for 8 years. Machines that are used for a variety of state and federal elections and even union elections and other elections. Whether it was because of those factors or any other factors, we respectfully submit to the court is not really the question. What is important is that we now all know from the record in this case that in a significant number of instances, not even 5% or 10%, but down at the level of 1 or 2%, maybe not enough to make a difference in most elections, but many times more than enough to make a difference in this election, you have ballots that, for whatever reason, are not machine readable. Whether it's the people or whether it's the machines, and we've submitted, we think, a lot of evidence that it's not the people, that it is the machines, but whether it is the people or whether it is the machines is not the critical question. The critical question is, are there votes out there from which a review of the ballot can